So, good day everyone. I am the presenters for today, and our subject for today is application and contract. So, our topic for today is Article 1169 to 1173. Let's begin. Article 1169, those obliged to deliver or to do something incurring delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. So, sinasabi dito sa Article 1169 is about delay, so incurring delay. And, however, the demand by the creditor shall not be necessary in order that delay may exist. So, yung demand by creditor, hindi siya necessary at yung nag-i-exist yung tatlong to. So, yung sinasabi dun sa number 1 is dapat daw yung gagawin demand ng creditor is acceptable and based on law. And then yung sa number 2, dapat time-oriented yung gagawing demand o bibigyan ni creditor ng sapat na oras sa debtor para mabayaran yung debts. And then yung 3, let's say yung demand ni creditor ay acceptable with the laws and has enough time para mabayaran ni debtor his debt. The demand will be useless if the debtor doesn't have the capacity to pay, means walang mapagkukunan sa debtor ng pera para mabayaran yung utang. And then yung sa in reciprocal obligation, ito naman yung sinasabi ng no demand, no delay. Walang delay if walang demand na nagawa at both parties agreed upon. Magkakaroon ng ganung delay if the debtor agreed on the demand created by the creditor. So, what is delay? Used in the law is not to be understood according to its meaning in common parlance. A distinction, therefore, should be made between ordinary delay and legal delay, default or mora in the performance of an obligation. So, mayroong two types of delay, which is ordinary delay and legal delay or default or mora. So, ordinary delay, it is merely the failure to perform an obligation on time. So, yung example dito is, si debtor, willing siyang mag-deliver ng bike to creditor this day. But, in personal reason or in any reason that debtor delay to deliver it today. So, hindi na perform ni debtor yung obligation niya na magbigay ng bike dun sa creditor. So, kinabukasan, naka-experience siya ng delay kasi dapat kahapon niya ibibigay pero ngayon niya nabigay yung bike. So, ayun yung tinatawag na ordinary delay. While in legal delay or default or mora is the failure to perform an obligation on time which failure constitutes a breach of the obligation. So, yung legal delay, ito naman yung sinasabi na kapag nag-fail daw ay nagko-constitute ng breach of obligation and ito na yung mismo tinutukoy sa Article 1169 na legal delay. When you incur legal delay, dito na rin papasok yung obligation to pay for damages. So there are three kinds of delay, default or mora. So first is mora solvendi. The delay on the part of the debtor to fulfill his obligation to give or to do by reasons of a cost imputable to him. So, yung mora solvendi, tinutukoy niya yung debtor. So, si solvendi ang may delay. So, si debtor ang may delay dito sa mora solvendi. Siya yung hindi nakapag-fulfill ng obligation by any reason. And then dito sa mora assistendi, ito naman, failure naman to ni creditor. Failure to ni creditor to accept the performance of the obligation. So, guilty si creditor because he delayed to accept the performance of the debtor. And then yung compensation mo rin naman, the delay of the obligor, reciprocal obligation, Ito naman yung parehong may delay si debtor and creditor to perform the obligation. Pinagsama tong mora solvendi and mora assipendi. Diba, sabi natin kanina, yung mora solvendi ay yung delay ni debtor. Tapos yung mora assipendi ay yun naman yung delay ni creditor. So, kapag parehas nag-exist yung dalawang yun, tinatawag siyang compensation mora. Kasi, yung both na yun, the delay of the obligors cancel the delay of the obligee. So, ayun yung tinatawag na compensation. Next. Requisites of delay or default by the debtor. So, yung number 1 is failure the debtor to perform the obligation. Ito naman yung nag-fail si debtor na i-perform nga yung obligation niya dun sa creditor. So, yung demand, ito naman yung hindi na-fulfill ni debtor yung demand sa creditor. Ito naman sa failure the debtor to comply with such demand, nag-fail naman dito si debtor na mag-comply ng mga demand. So, next is the effect of delay. So, yung ano dito is yung delay. Ano yung epekto ng delay sa tatlong to? Sa mora solvendi, sa mora assipendi, at sa compensation rate. So, dito sa mora solvendi, guilty si debtor. Kasi di ba si solvendi, ang ano dito is si debtor. Si debtor yung may delay. So, si debtor, guilty siya kasi hindi niya na perform yung obligation niya. Dito naman sa letter D is liable siya dun sa interest. Ito yung may babayaran siya mga damages. And then, letter C, ito naman yung liable siya for a fortuitous event. And sa mora assipendi naman, which is creditor naman yung pag-uusapan natin, guilty si creditor kasi nag-fail siya or nag-delay siya na i-accept naman yung obligation ni o yung performance ni solvendi, which is debtor. So, yung letter B naman is liable naman siya sa damages na na sinasuffer ni debtor. So, siya naman ngayon yung liable dun sa mga damages. So, dito sa letter C, bears the risk of loss of the things due. So, kung na-delay si creditor na i-accept yung performance ni debtor, ayun yung magkakaroon siya ng risk of loss of the things due. Kumbaga, parang mababawasan siya ng mga bagay na kailangan niya. So, yung letter D naman, the obligation is to pay money, the debtor is not liable. So, dito naman, sa delay, si debtor, hindi siya liable na bayaran yung interest na nagawa ni creditor. Diba? Kasi si creditor yung may delay dito. So, si creditor lang yung obligadong magbayad ng pera para dun sa interest. And dito sa letter E, the debtor may release himself from the obligation. So, si debtor naman, kaya niyang i-release or alisin yung sarili niya dun sa situation na si creditor yung may gawa in terms of delay. And then, dito naman sa compensation rate, ito yung the delay of the obligor cancels out the effect of the delay of the obligee, and vice versa. Ito nga yun yung parehas silang nag-cancel out. Parehas silang may delay, si solvendi and si assipendi. And there is no actionable default. Kumbaga wala siyang, hindi siya magagawa ng action or parang solution dun sa both parties niya. Okay, next article, Article 1170. So, Article 1170, those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. So, fraud. It is the deliberate or intentional invasion of the normal fulfillment of an obligation. So, example dito sa fraud. Nag-order si engineer ng 60 reinforcing board sa supplier. Pero si supplier, nag-deliver lang siya ng 20. So imagine, si engineer nag-order ng 60, pero 20 lang yung dumating. So ibig sabihin, intentional yung ginawa ng supplier yun sa engineer. Kasi alam niya naman na 60 yung in order, pero 20 lang yung dumating niya. So ayun yung sinasabi dito na intentional deviation is the normal fulfillment of an obligation. Next is negligence. It is any voluntary act or omission, there being no malice which prevents the normal fulfillment of the obligation. So, yung sa negligence naman, example naman dito is yung sa engineer, siya yung voluntary siyang nag-check ng mga construction materials para maayos itong magamit sa mga projects nila. Kasi if nag-fail siya, if the failure of his duty is constitute negligence. So kapag nag-fail siya, negligence yung matatawag yun. So next is delay. It has been ruled that the delay in the performance of the obligation under Article 1117 must be either malicious or negligent. So dito sa delay, ayun yung if either malicious siya or negligent. And na-discuss na rin natin kanina yung about sa delay. So parang sinasabi dito kung kailan magkaka-delay at yung mga effects ng ay yung mga effects ng delay sa pagpa-perform. Contravention of terms of the obligation, meaning this is the violation of the terms and conditions stipulated in the obligation. So, ito yung both parties have a contract and doon nakasulat lahat ng mga violations and conditions ng both parties na yun. Stipulated in the obligation, but if they're not following, if hindi sila hindi nila pina-follow yung terms stipulated in the contract, can be considered as contravention of the terms of the obligation. So, ito naman yung fraud versus negligence. Pag sinabi natin fraud, ito yung nga, kanina, intention. Intentionally ginagawa para makapas ng damage or injury. While sa negligence, no intention. And the fraud is waiver of the liability for future fraud is void. So ito daw, liability daw, yung waiver daw ng future fraud is void. So itatakal din natin yung later on. And then, so negligence is waiver may be allowed in a certain sense. And then, the fraud must be clearly proven. And negligence naman presumed from the violation of a contractual obligation. And the fraud is liability cannot be mitigated or reduced to regard. So yung fraud, hindi siya ma-reduce by the court, ng court. While the negligence, liability may be reduced according to circumstances. So, pwede siyang mag-reduce according to the situation or circumstances. Next is Article 1171. So, Article 1171, responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. So, this Article 1171 is it refers to incidental fraud which is employed in the fulfillment of an obligation. So, tinutukoy dyan yung incidental fraud. So, ayan, two types of fraud. Number one is incidental fraud, two is casual fraud. Yung incidental fraud, it is employed within the fulfillment of an obligation, while the casual fraud employed in the execution of contracts in order to secure the consent. So, responsibility arising from fraud is demandable. Demandable siya kasi um, demandable siya kasi hindi siya kagaya ng negligence. Kasi yung fraud, intentional siya, serious, and detailed, unlike negligence. So, waiver of action for future fraud is void. Void siya kasi it is against the law and public policy. For example, lolokohin ka pa lang in the future, then nag-oo ka, then ano yun, hindi pwede yun, void yun, kasi nga, against yun sa public policy and law. Kasi gagawin pa lang sa'yo in the future. Diba? So, dito naman sa waiver of action for past fraud is valid. Valid siya kasi nagawa na sa'yo, pero, naloko ka na, pero napatawad mo. And tinatawag yung considered as an act of generosity. Kasi, napatawad mo yung ginawang panloloko sa'yo. Then, Article 1172. Article 1172, responsibility arising from negligence in the performance of every kind of obligation is also demandable, but such liability may be regulated by the courts according to the circumstances. Okay, sinasabi dito sa Article 1172 is all about negligence naman siya. So, responsibility arising from negligence is demandable naman. Kanina, sinasabi sa Article 1172, si fraud daw yung demandable. Pero dito sa Article 1172, si negligence naman yung demandable. Yun, kapag negligence, the court may mitigate the amount of damages to be amended. Unlike fraud, na hindi talaga pwede because negligence, as serious as fraud, there is no bad faith or deliberate intention. So, validity of waiver of action arising from negligence. An action for future negligence may be renounced except where the nature of the obligation requires the exercise of extraordinary diligence as in the case of common carrier. 2. Where the negligence is bad faith, it is considered as equivalent to fraud. So, yung dito sa validity of waiver, valid ito except the nature of the obligation of extraordinary diligence. Pero, if itong negligence ay nagpapakita ng bad faith, considered na to as equivalent to fraud. Any waiver of an action for future negligence of this kind is therefore void. So, kapag ginawa mo daw yung negligence, in future, void daw siyang matatawag kasi nagkakaroon ito ng bad faith. So, ito yung sa kinds of negligence, contractual negligence or culpa contractual is not the source of obligation. Next is yung civil negligence or culpa acquirenia, means which by itself is the source of obligation. So, ito naman daw yung source of obligation, but the contractual negligence is not the source of obligation. And then yung pangatlo is criminal negligence or culpa criminal. Ito naman yung results ng crime na ginawa. Resulting in the commission of a crime. Next, culpa contractual and culpa filialia is important in our jurisdiction. So, Article 1173. Article 1173. The fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of the time, and of the place. When negligence shows bad faith, the provision of Article 1171 and 22001, paragraph 2 shall apply. The law or contract does not state the diligence which is to be observed in the performance that which is expected of a good father of a family shall be required. So what is fault or negligence? It is defined by the above provision, and according to our Supreme Court, negligence is conduct that creates undue risk or harm to another. So factors to be considered. Number one is yung nature of obligation. So yung example nito is yung smoking while carrying materials known to be inflammable constitutes negligence. So, syempre, yung may isang taong naninigarilyo tapos hawak-hawak niya is yung material na kailangan for cremation. So, di ba parang constitute siya sa paggawa ng negligence. So, second is yung circumstances of the person. Example nito is yung a guard, a man in the pride of life, robust and healthy, sleeping while on duty, is guilty of negligence. So, yung bodyguard daw is natutulog siya sa oras ng trabaho. Sa oras ng, ng time niya. So, di ba? One of the, factors na paggawa ng negligence. So, guilty yung tao niya sa paggawa ng negligence. So, number 3, circumstances of time. Ito naman yung nag-drive ka without headlights at night. And is gross negligence, but it does not by itself constitute negligence when driving during the day. So, itong circumstances of time, nakakagawa ka lang ng negligence kapag kapag wala kang light ng headlight every night. Pero kapag sa gabi, okay lang na wala kang headlight kasi umaga naman yun. Diba? And hindi ka naman, wala ka namang, kumbaga parang, iwas siya sa disgrasya, unlike kapag gabi na wala kang headlight. So, number 4 is circumstances of the place. So, ito naman daw yung nag-drive ka ng 60 kilometers per hour. So, diba parang delikado yun. Kaya parang, factors to be considered din siya pagdating sa lugar. So, kinds of diligence required. So, ito yung not agreed upon by the parties orally or in writing. And the next, in the absence of a stipulation that required by the law in the particular case. Dito is yung nag-agreed sa parties orally or even in writing. Dito naman is kailangan required by the law in any particular case. Last is, if both the contract and law are silent, then the diligence expected of a good father of a family. So, kapag yung contract and yung law daw ay silent or tahimik lang, then the diligence expected na of a good father of a family. So, that's all, and thank you for listening.